Out of respect to our presenters, I would like to keep the meeting on time, but I am receiving messages that there is some terrible, terrible traffic and a number of people are stuck. So welcome to the Budget Review Subcommittee on Justice and Judiciary. What I've recognized is it's so helpful, and I want to appreciate KET for filming these meetings too. So given the opportunity to see the testimony on a later date, there's a time and a place that you can find that. So thank you. And we're going to roll through past, I will say, the roll call as well as the approval of the minutes because we do not have a quorum. So I would like to go ahead and invite the Department of Public Advocacy, Alternatives to Incarceration, and Attorney Compensation. Please come forward. And if you would, remember to press your green button and introduce yourselves. And then you may proceed.
Good morning, Madam Chair. Thank you for this opportunity to be before the committee. It's always an honor to speak at any of the committees, but particularly this important budget subcommittee that has important decisions to make in the next 12 months. My name is Damon Preston. I'm the public advocate, commissioner level head of the Department of Public Advocacy. I'll let my other guests introduce themselves.
Good morning. My name is Melanie Lowe. I'm Deputy Public Advocate, the Assistant Commissioner to Mr. Preston.
Good morning. My name is Tina Meals. I'm the Alternative Sentencing Worker for the Bell County Public Defender's Office.
This morning we've been told that what you would like to hear is information related to two separate topics: attorney compensation and DPA's role in providing alternatives to incarceration. We're honored to be asked to present those. I'm going to start talking about our attorney compensation, the issues that we face with that, and then we will turn to our alternative sentencing worker program in a few minutes. First, I want to just give you a general snapshot of DPA as an agency. We, of course, are a full state agency. We have 698 employees total. I should say that 698 positions that are funded. That is, if we had all the positions filled, we'd have that many employees. We have not had that since post-COVID for about, and this is a literal truth, for about 1 week in 2021, we had full staffing. And then a couple people left and the race was on. We're trying to get back there. Of that 698, about 400 are attorneys and about 298 are non-attorneys. I say it that way because that's fluid. If an attorney leaves and we fill a secretary position, it's not exactly that. But that's about the ratio. At the current moment, as of July 1, we had 673 filled positions. Simple math shows that's 25 vacancies. We do on August 16th, we are scheduled to have 42 class of 25 law graduates. Right now, maybe next week, they'll be taking the bar exam, so they don't join us until August, but we wish them the best, and they will be joining us August 16th. That will get us to full staffing, and in fact, maybe even put us a little over if we don't have a mass resignation between now and then. So we will be happy with that. I'm going to talk about turnover, which is why I have confidence that we'll be able to afford those employees, even if we briefly go over our funded amount. I want to start talking about compensation by reminding you of some decisions that were made a couple of years ago. And before I talk about the specific decisions, let me just say, over the next 6 or 7 minutes, I'm going to be saying a lot. I'm going to be talking a lot about resources that have been given or are currently in the budget for prosecutors. Nothing I say is intended at any level to be they shouldn't have that. In fact, it's to show what a reasonable funding would be for a state agency. I want to commend the Commonwealth Attorneys Association, the County Attorneys Association, PAC, the Attorney General, for their effective work in communicating their needs and convincing the legislature to fund them at the current level. And I want to thank you all for funding them and giving them what they need. We need a well-funded prosecutor office. And so none of this is a criticism of that funding decision or where they are. It's simply, my goal here is to communicate the disparity between the defense side and the prosecution side, and to talk about what the effects of that disparity some. So part of that disparity was a result of the 25-26 budget bill, which had these 4 paragraphs that are, they weren't in order in the bill. I've cut them to put them on the slide, totaling almost 20 million, about 17 million here. There were some other parts in other parts of the budget bill. In the end, it was a little over $20 million of additional funding was given on top of what their previous budget had been for the purposes of salary standardization and additional personnel. Now, I told people at the time when we were negotiating our own budget, trying to get some, the effect of this is going to be we're creating new prosecutor positions at higher salaries. That's going to lead to resignations from DPA for people to go take those positions. And in fact, we have seen that. And we're going to talk about that some. We've got some specific examples in a little bit. So this funding was provided to prosecutors, was not provided to us. 2 budget cycles ago, we did get some additional money for higher salaries, and we were very appreciative from that. This was not a response to that because prosecutors were also given funding when we did 2 cycles ago. So in the end, these are the aggregate numbers. Unified prosecutorial system, just to use the bottom line numbers here, for this fiscal year that we're now in, 170 million for the unified prosecutorial system, 105 million for DPA. We, in March of this year, did a complete, exhaustive survey of all the staffing in DPA offices and in local prosecutors' offices. And what we figured out was there are 366 lawyers in DPA trial offices, 555 full-time prosecutors in local prosecutors' offices, 155 part-time prosecutors on top of that. Now, I want to be very clear. These are not estimates. This is not that I asked the hazard office how many people are in the office, and they said, well, I think there's 4. This is not there are 4 people in the office. This is there's George, there's Paul, there's John, and there's Ringo. We know who they are. We have a list of these 555 people. We have a list of the 155 part-times on top of that. So this was an exhaustive study that I wanted to know who are these people, because there are occasionally I hear people say, their DPA's got more people than I've got. Well, I can't speak to any particular courtroom at any time, but that is definitely not true in the aggregate. And if it happens in a courtroom, it's because we have so many clients, we have to put additional people there. And every lawyer that's in that courtroom is also in district court, is also in family court, is also in juvenile court. So this is the disparity in the number of positions. Now, I'm here to talk about compensation, but this is part of the context of why people leave us, is because there's so many positions available. When it comes to funding sources, DPA is simple. We're 100% funded by the state. We have no other sources. We don't get we get some revenue that comes funneled through the state. So this is all part of that funding. That's part of that budget line that I showed. That's all we get. I should also point out, I keep using the phrase trial office here. I want to be clear. The reason I'm using that is because that's the closest apples to apples that we can do. DPA has other parts. We have a post-conviction unit. We have appeals. But appeals, the other side is in the AG's office, and the AG does so many things other than criminal, so that's hard to do. So all of my comparisons here are trial office DPA to trial office prosecutors, Commonwealth attorneys, county attorneys. When it comes to those local prosecutor offices, they get the state funding at about 60% higher than all of DPA's funding. That was the number I showed earlier. They also have some funding from cities, some funding from counties. They get money from forfeitures. They get money from traffic safety programs. They get grants. Again, none of that, I'm not complaining about any of that. Those are all legitimate sources of funding that are targeted to public safety, and the Commonwealth's and counties' attorneys are an important part of our public safety system. I'm simply pointing out that when we compare the resources with DPA, it's all state money. That's the only resource we have. And so now let's talk about compensation. This graph is if you total up all of the salaries, none of the benefits, none of the side other costs of expenses, none of the office space. This is simply totaling up the salaries. DPA again, trial offices, so it's apples to apples. Trial office, DPA attorneys total up to 26 million. Prosecutors on state funding that is accessible through transparency.ky.gov, the open door system, those salaries, which we've looked up again, and we know who these people are. We've looked up their actual salary. It totals $41.9 million. These are all pre-July 1 numbers, I should point out. All state employees got a 3% raise on July 1, so both these numbers would be slightly higher now. So that's the comparison there. And then that purple on this graph, the additional $10 million, let me explain what that is. When we went through our exhaustive survey of DPA salaries and prosecutor salaries, there are people that we know are full-time, to use my Beatles example. We maybe John and Paul are listed on the state website. Well, we know Ringo's a full-time prosecutor because we see him in court all the time, but his name's not there. So there are over 100 real prosecutors that are real people prosecuting cases whose salaries are not listed on transparency.ky.gov. Our best guess for that is because they come from sources other than state funding that's required to be reflected on that website. If there's another explanation, I'm happy to hear it. That's my explanation. That's the best we can come up with. Those 100 people, and it's a little over 100, we've estimated that they're. I put in a salary of $85,000. Now, we're going to see on the next slide, I think, the average salary is higher than $85,000, so that's probably a low estimate. But I wanted to be conservative. But if you put that over 185,000, you get close to 10 million. So that's on top of that. So total prosecutor compensation is a little over $50 million. DPA's is 26. So it's almost double.
Damon, thank you so much. I'm going to
Please
pause
ask
you
any
for just a
questions.
moment.
Yes.
And if there are any other questions, which I sense that there are, one question that kind of strikes me, of those that are charged with a crime, what percentage are self-funded defense?
Yeah, that's a very good question. So we did a study, I think it was in 2017 of that. And at the time, and there's no reason that it would have gone down. It might have gone up since then. But in 2017, we estimated that about 50% of misdemeanor cases or district court MF cases, those are the case numbers, MF, are handled by private attorneys or not by DPA, I guess would be the more proper, because they could be pro se or privately represented. In circuit court, it was 75% of CR cases are handled by DPA. And then within circuit court, as you get to the more time-intensive, labor-intensive cases, like death penalty cases, serious sex cases, child cases, those, once you get high enough, they're almost exclusively DPA because not a lot of capital defendants can afford to hire a private attorney. So the more labor-intensive case is, the more likely DPA is in it. But overall, at that circuit court level, it was around 75%.
So if you don't mind, go back to your previous slide right there.
That one. Is that what you want?
No, the one where you compared apples to apples budgets. Full-time public defenders, 73,000. No, the one that acknowledges, yes, 365.55. So
that one.
if we've got 555 plus 155, they're prosecuting.
Right.
We're not going to privately prosecute. We're only going to publicly prosecute. Okay. So then the trial offices having 366, it should be about 50% of the number, right? If what you're just sharing, private attorneys need to be hired. And I've talked with you about this where I'm a bit concerned that we're exuberantly offering our services for free, thanks to the taxpayer. And I look around my own community and feel a little concerned that I want to better understand the measurement of what determines having a public advocate versus a private attorney.
Sure. So quite a few issues there, obviously. I'll start with the last. We also don't want to be representing cases when somebody should have a private attorney, and we will gladly step aside when somebody hires an attorney, or if a court says you don't get a public defender. Historically, as DPA has been evolving over the last 50 years, there was a problem many years ago with not appointing people for invalid reasons. And so you would wind up with people who can't afford a lawyer, are denied DPA, and they wind up at the podium in a serious case without a lawyer. That doesn't happen that much anymore, but I'm open to the argument that we've swung too far the other way, that we're giving DPA in too many cases.
And those are the statistics that you and I talked about. And I know, Melanie, I was so glad to meet you some months back. I'd like to see that. Like, what are the statistics? How has it risen? If we look at the past 10 years, and are we seeing it on a downtrend? More people are coming to defend themselves and their honor with a private attorney, or are we actually trending up with public advocates? I'd like to see the trend. From a fiscal matter.
Percentage of appointments? Is that what you're asking?
That's right. That's
Okay.
right. Because this is a fiscal conversation. I'm not trying to be critical about the system.
Yeah.
I'm just trying to recognize the fiscal influences.
Yeah, I think those would be good. And we can try to get that over a period of time. I will say that I think anecdotally there are also more people who can't afford an attorney than there used to be. The private bar, there used to be more of a criminal private bar, and it was more along all pay scale levels. Like there would be, to put it simply, a cheap criminal defense bar that doesn't exist that much anymore. But also people there are a lot of poor people in Kentucky. And so if it has gone up, that's part of it. The other thing I would say is I don't believe these numbers that are on this screen are supportive of the claim, because 50%, I say that because that was what the misdemeanors show, but misdemeanors are such a small part of what we do. Most of our attorney time are taken on those long circuit court dockets, and we're 75% in those cases. And again, on the most labor intensive, we're far higher than 75%. And so these numbers is about 60% what it is here if I'm ignoring the part-time. If you add the part-time, then you're over 700. It's almost double. There's no way that accurately reflects the workload when it comes to workload, because the most labor-intensive cases, we're handling those cases.
Thank you. That's helpful. And you can proceed, but
Yeah,
I needed to put my head around that.
Yeah, I appreciate those questions. So here's our general pay schedule for DPA. Our starting law clerk salary right now is $51,000. As of July 1, our starting attorney salary jumped all the way from $57,000 all the way up to $58,200. Our experienced attorney salary, if someone comes to us with a little bit of experience, they're going to make $61,000 when we hire them. I'll just pause here before I talk about what anybody else makes in the system. The fact that in 2025 we've got somebody that incurs all the debt and goes through law school and college and comes out, they want to serve. The state has a constitutional obligation to provide a defense attorney, and all we can pay them is $58,000. I think that's, irrespective of any other information I give you, this is too low. It's just too low. But that's what we can afford, because again, we have 400 lawyers. So if I raise this $100, that's a significant amount. This is what we can afford to pay our new lawyers. So they're coming to us, again, $51,000 before they're licensed, and then $58,000 when they get licensed. And so here is the average salary of unelected prosecutors versus the average public defender. $73,000 for public defenders. Those are our experienced people. That's with the raises that you funded 2 cycles ago. So that raised us quite a bit to get to that $73,000. Unelected prosecutors, because there's no reason for elected prosecutors to be here, because number one, they don't have discretion over their salary. They all get paid the same. And just on the math, the Commonwealth attorney right now, actually I haven't looked to see what they're making after July 1. I believe on June 30th they were making $157,000. That would 159. Thank you, Rob. So that would skew the math here, and that's not my intent. My intent is apples to apples. Our people aren't elected, so let's look at their unelected people. So that's about 25% more that they're making than our average salary. This is something that I think more states kind of what my issue is. Because there's two, if you're a young lawyer, there's two things that matter to you. What am I going to make today? And what's the pot of gold at the end? If I stick with this job, am I eventually going to be doing okay? 100,000, every year with inflation, 100,000 means a different thing, but it's still a symbolic number. And if you look at who in the public state-funded criminal system attorneys, that's my general phrase for prosecutors and defenders, how many are making that symbolic amount? Well, there are 11 public defenders, and they all have 15 to 20 years experience. They are in significant leadership positions. That's the only way somebody gets to that number for us. For prosecutors, here I do include the elected because they are there. So that orange box are the elected Commonwealth's attorneys, every 57 of those who do make that. But the unelected, there's almost 80 of those compared to the 11 defenders. So 133 overall prosecutors were making that, again, pre-July 1, and 11 public defenders. Here's the effect it has on us. So our turnover rate's about 20% for attorneys. I include our non-attorney rate just kind of as a control group there, because it's important to me. If we had 20% rate on everybody, then maybe it's an us problem. Maybe it's a culture issue. Maybe it's something we do. But our non-attorneys have a pretty low turnover rate. But our attorneys are 20%. But more than that's that last column, the median service time before separation. How long are they staying with us before they hit the road? And in 2024, it was just 15 months. Half the people who left us, 1 in 5 attorneys left us, and half the ones who left us left with just over a year of service. It's gone up slightly. Unfortunately, that's going to go down because among those 42 people who start in August, what we know from prior years is some of them are going to be gone by December because they're going to decide this isn't the job for them or they find another opportunity. So that's probably going to wind up being 15 months again. And in exit interviews, because we study this stuff, we do 1 and sometimes 2 exit interviews for everybody that leaves. The most common reason for attorneys is I can't do it. I can't do it on this salary, and there's another opportunity elsewhere. Here's our years of experience just to show this is a kind of another way of saying the same thing I just said. Most people are leaving, a plurality of people are leaving early in their career. And then what this tells me is if we can hold on to them for 4 years, there's a good chance they're with us for a career. And so as they're with us longer, the chance they're going to leave goes down. Over 20, it goes back up a little bit because that's when people start retiring. So now we want to give some specific examples of people who have worked for DPA that are now working for prosecutors. Here, I'll just advance if you're ready.
Yeah. So we wanted to give you guys some specific examples of attorneys that have worked for the department that have gone to work for the prosecutorial system. And to be clear, these are not call-outs for employees. These were great employees for us. We appreciate the years of service, the time periods that they put in working for DPA clients and doing that work. And we're happy for them that they are able to move on with their career, get some different experience, and we all work to make money and to be able to be compensated better for the skills that they bring to the table. We're happy for that, for them, for those individuals. And so this isn't meant to be a call out for those persons. This is meant to demonstrate that we would really like to be able to have our people who are doing also very important work for the Commonwealth be compensated at a more equal in a more equal manner. So let's talk specifically about TK. TK was a attorney that worked for us for 3 years. That attorney in a local trial office made a salary of $69,494. In that position, she handled both district court cases and circuit court cases. And in 2025, she went to work for the local Commonwealth Attorney's Office. Portion of her salary is paid by the Commonwealth Attorney's Office, and then she also works part-time in district court, and so a part of her salary is made up from county attorney funds. So as in 2025, working full-time for the prosecutor, just like she was working full-time for us doing district and circuit court, her salary is $92,429, and that was a 33% increase and a great increase, and probably very, very valued skills that she brought to the table that are very worthy of that and more. Another one of our attorneys, AJ, worked for us for 20 years. AJ's salary with DPA in 2024 was $78,239. In 2025, AJ went to work for the local prosecutor, making $106,200. That was a 36% increase. Again, we're happy that AJ is able to get compensated better than we had been able to pay AJ, and we're happy that the Commonwealth is still benefiting from that person's skills and experience. One of the ones that's most concerning to us as an agency is LJ, who is a trial office supervisor. This is a local office directing attorney who's in charge of training and supervising all of the staff in that trial office. That individual's DPA salary in 2024 was $94,963. When that attorney, LJ, went to work for the prosecutor in 2025, she was getting a salary of $106,200. That was a 12% increase. However, LJ was able to take a position that is not a leadership position with the prosecutor's office, not supervising people, not worrying about necessarily all of the headaches that go on with running a trial office, is able to focus primarily on a practice. The last example that we have is AS, an attorney for us that worked for us for 8 months, representing our DPA clients, and had a salary of $59,850. After 8 months, AS left to go be a prosecutor, in 2025, making $90,000. That was a 50% increase for AS. And again, we are happy that AS is able to go and get better compensated after years of going to law school and incurring the debt that was involved there. We just wish that our new people would be able to benefit from salaries closer to that.
So we appreciate this time to be here to talk about salaries. That we have a balanced justice plan for our budget. I'm not going to go through it. That's not what we were asked to present on. We would love to be invited back or to come talk to you individually about our full budget request for next year. It's these six plans, but number one is professional defender compensation, to allow our public defenders, if they want to stay with DPA, that they can do so. They can provide for their family. They can put a down payment on a house. They can do what they need to do without leaving DPA. Now, I want to turn to Ms. Mills, who's going to quickly tell us a story from her experience as an alternative sentencing worker. Our ASW program has been around for 20 years at this point. It's received national attention and national awards from Harvard and different groups. Rather than go through all the details of the program, which would take longer than we have, I thought a good, efficient way of doing it was just to invite one of our great ASWs that's been with us to tell us the story of one of her cases. So I'm going to turn it over to Tina Mills.
Thank you, Damon. I'm grateful for the opportunity to be here and to be able to share one of my clients' success stories with you. Individualized treatment placement can lead to so many positive changes. Adding additional resources to assist with client need, such as job training, not only enhances individual opportunity, but also promotes stable living and encourages continued sobriety. Nearly 1 year ago, I had the opportunity to work with a client named Patrick. Patrick had 2 pending cases. He had spoken to his attorney about possibly going to treatment as part of a court resolution. His attorney, Jared Portwood, had asked me to assess Patrick, find a facility, and prepare an alternative sentencing plan to present to the court. His criminal history was minimal, but he was facing 1 to 3 years incarceration for a possession charge. Before we even finished completing the assessment questions, Patrick asked me about a specific nonprofit program that another inmate had mentioned to him. That program was horse fencing, located in Shelbyville, Kentucky. The program allowed for clients to not only work with horses, but also to work toward obtaining an equine certification prior to completion of the program, while also getting needed substance abuse treatment. Although the program was initially started to assist with veterans treatments, it was later opened up and expanded to include non-veterans. I remember looking at Patrick. He was very pale and thin, probably from his recent drug use and the stress of being homeless. I explained the physical requirements to Patrick and the long work days that occurred.
That's an Amber Alert. I don't know how you shut that up. Apologize.
I do have my eye on our Kentucky State Police, and he's not given us any instructions.
Yeah, missing Judy.
Okay. So I was talking about Patrick and explaining the physical requirements to him and the work days that occurred at the horse sensing program. Patrick was adamant that he could do physically challenging work. Patrick said that he needed more than just counseling. He wanted to get out of the Bell County area, and he wanted a future. He said that if he did not get the needed help, that he would eventually have more criminal charges, or he would end up dead. Patrick asked me to contact the facility to see if he was eligible before I even discussed other treatment options. After leaving the jail, I immediately went back to the office. It's okay. Okay, so after leaving the jail, I went back to the office and I made a referral to the horse sensing staff. There was one bed open, and the director promised that she would call the jail to speak with Patrick to see if he was a good fit for the program. The following morning, I received an email with an attached bed letter indicating that a bed was available upon approval of the court. Patrick's attorney and I stood next to Patrick in court the following week and presented my alternative sentencing plan. Initially, the judge was very hesitant about allowing Patrick to complete this program. He actually stated that he was inclined to say no. He said that he had never heard of the program or any program like it. I asked Judge Oakham if he would further consider letting Patrick go if I were able to present letters of support from other judges who had allowed defendants to go there in the past. He said that if I could provide letters of support from other judges, that he would consider it further. I was able to provide several letters, and Patrick got to go to treatment. Patrick's attorney was able to negotiate an agreement with the court that allowed his case to be treated as a misdemeanor, and Patrick was able to avoid a felony conviction. Several weeks into his treatment, the facility director notified me that Patrick was doing amazing and that he was really involved with his drug education classes. And she said he was a natural with horses. Within a few months, Patrick had also earned his equine grooming certification. He has not only received treatment for his addiction, but was also able to overcome barriers to recovery, including homelessness, unemployment, and lack of social support. Although Patrick has completed all phases of treatment, he has chosen the option of continuing with the horse sensing program as an assistant training. He enjoys his job and continues to mentor other clients. I'm very proud of Patrick and other clients like Patrick. Patrick is a wonderful example of how individualized treatment does make a difference and facilitates positive impacts not only for the client but also for the community. Thank you.
That is so wonderful. Thank you for sharing that story. Are you prepared to receive some questions?
Yes.
Okay. I do think we have a few. But I'd like to start. Do you have an understanding of what that cost for that program that Patrick was placed in versus the cost of jailing him for 3 years? Well, you said 1 to 3 years.
Right. The program itself is actually free to all males that go to that facility. It's not, Medicaid is not billed. It is covered by other sources. As far as the actual cost, I would have to defer to Damon for that. It's like for every dollar spent, maybe like $3 in savings or something.
Generally, our program in the past has been studied by experts at UK and U of L, and the savings is $1 invested in somebody like Tina returns $3 to $6 in saved incarceration expenses for the alternative sentencing plans. That's not for this case specifically, but that's our general study.
So the alternative sentencing plan does still involve the prosecutors. You have to kind of agree or negotiate.
It becomes right.
Rather than, and then the ongoing process of supervision for Patrick What's the cost associated with that?
Okay, he actually was not placed on probation. It was a diversion program. So he's not actually being supervised by probation. He is participating in a program. He's completed all phases of treatment. So at this point, he is still living at the facility. He's working. He's not being monitored, except for by the facility, who still requires random drug testing. Sorry.
Sure. And going back to that, today he's not being monitored, but at the point of agreement to that diversion,
He was incarcerated, yes, ma'am.
in that period of time of some sort of supervision, what is the cost there from the point that you've made this agreement? He's now left the jail. I assume he was in jail.
He was.
So help me understand the costs associated with that. Because what length of time then was he on probation or being monitored?
If I could be helpful, with regard to misdemeanor courts, probation and parole, the state agency that supervises individuals who are on probation, conditional release, or diversion, that is they typically only supervise folks who have felony convictions out of court. Sometimes they will supervise people who have misdemeanors in conjunction with felonies. There is not a state agency that handles post-conviction supervision for individuals with misdemeanors. There are some private companies who provide those services at a cost to the probation So, for example, an individual would pay for drug testing and supervision through a private company who's convicted of a misdemeanor, where those programs are providing services for the local court. So it'd be difficult, I think, for this particular individual, for Patrick. He went directly from incarceration to this residential program, which is why I believe that the judge was in agreement with providing the offer that he received. And there at the treatment program, he was being supervised, being provided with what we would see as supervision just through the program to benefit their program.
And I would imagine we're pursuing self-sufficiency. So
Yes.
your story seems that we've brought a person in a more self-sufficient path.
Yeah, absolutely.
And as I, again, try to keep the numbers as our primary objective to understand, the gentleman then no longer has the misdemeanor on his record. If he wanted to come work for FFR Wealth Team and I ran his criminal and credit, would it show up as a misdemeanor?
It would show up as a misdemeanor, but he was facing a felony charge, and that would not show up.
Okay, good. Thank you. Thank you so much. That's very helpful. And then Senator Webb?
Thank you. And mine's more comment because I'm pretty well versed in this area after almost 40 years practicing law. And as a young lawyer, taking on a lot of public defender contracts, we then too had a real problem in retaining lawyers. So I think at one time I had 5 contracts. And I've done that through the years, and I've done it as recently as a couple years ago. What started out as a 3-year ended up being, or 3 month ended up being a little longer because we couldn't get lawyers in Ashland. In the hub of East Kentucky, we could not keep lawyers. We could not get enough lawyers in Ashland. So I took a contract or 2. And I do that just for the purpose, because I want to get back. I enjoy that work. I'm a criminal defense lawyer primarily, and I have historically served on this budget committee. And everything you say is true, probably plus. In certain regions of, I'd call service deserts like we have in other things, because I happen to have lived in 2 of them, in Hazard area and even in Ashland, the more urban setting. And let me just say, as far as ASW, I wish we had a private practitioners as service. They're very lucky, and with the caseload, it's very necessary. And I work with national groups, along with Chairman Storm and others, about data-driven outcomes on programs like this. And it's positive, and it's real. And just like, we have had animal programs in our correction system that work too. They lower recidivism. They solve a workforce issue sometimes that we now have, especially in agriculture. And and it's the first time, if you talk to the inmates, that they've had a bonding experience, felt love, give love, and it works. So these outcomes are data driven. And I just want to thank you all for recognizing that. And yeah, just what I see, the turnstile, I'm in court all over the Commonwealth all the time, and I see a turnstile of public defenders. I get calls. I got a call from Wayne County the other day. They said, I'm set for trial in Hardin County, and my public defender's been working there like 3 weeks. How can he be ready to try my case? And so these are the real life stories that affect human beings and affect, you can't quantify. It's hard to sit here in this committee and do numbers because you can't quantify the savings. You can't quantify the human impact and the workforce impact and getting those people back into the workforce. Hard to quantify. We know incarceration costs a lot of money, and we know that some of this treatment works. So really hard to quantify numbers, especially when it comes to corrections. And I just want to thank you all for what you do. Some of the best lawyers I know are public defenders, and it's a calling, and I just appreciate y'all. Thank you.
Thank you, Senator.
Thank you, Senator Webb. Representative Kulkarni.
Thank you, Madam Chair. Thank you all for your presentation. Is it okay if I ask general questions apart from this last segment? Thank you. I want to echo Senator Webb's comments. Thank you for the work that you do. Working in the criminal justice system is incredibly difficult. I know I lack the constitution for it. It is a calling. That being said, I have a couple of questions about if, let's say I'm a new attorney and I'm interested in working for DPA and I'm planning my career, right, as you were mentioning. Typically, you've worked for a year, you work for 5 years, you have some expectation of salary increases. Are you all able to even predict or talk about that with a new hire, because it is all state-controlled funding?
So the typical path with DPA, we have 3 levels of staff attorney, 1, 2, and 3. The typical path is they'll come as a 1. After 12 to 18 months, they'll become a 2. That comes with a 5% raise. And then at around 3 or 4 years, they're eligible for a 3. Staff attorney 3s we define by policy to basically be you can take whatever walks through the door, from a traffic case to a murder case. So someone usually gets there around 3 or 4. That's another 5% raise. And then, of course, there's the annual increments. Beyond that, we are not able to provide part of what I have asked for in the past and will be asking for in the next session is the authority to have some flexibility on salaries, to where if Rob's office in Ken Commonwealth Attorney has a vacancy and they would like to hire one of our people, I would like the ability to match their offer. Right now, I don't have that. There's no mechanism in state government for me just to look at a person and say, I'll give you that 5% raise that he's offering. So we don't have that. So those stair steps are the only options we have. And then leadership requires 4 years of experience that they can then become a staff attorney supervisor if we have a leadership opportunity open.
Thank you for that. And a quick follow-up. The reason I asked that question, it was prompted by, I think, one of the slides when you were talking about the different examples of folks that had worked at DPA and left to join the prosecutor's office. And you had one example of somebody who worked there for 20 years, and when they left, they were making like 106. And then the last example was somebody who had just joined DPA and left and was making 90. So I'm thinking of somebody with 20 years of experience making just slightly higher than somebody that is kind of freshly starting out.
So I think you misread the slides.
Okay.
So you're looking, the top salary is our salary. We were paying the new person $59,000.
Right.
And then we were paying the 20-year $78,000.
So I was looking at the prosecutor 2025 line.
Right.
So the 20 years of experience, they went with 20 years of experience to the prosecutor's office, were making 106. I guess
Right.
this might be a prosecutor's office question.
Yeah.
I was just confused by those numbers a little bit. But that is an aside, because it was kind of leading into my next question, which was about caseload. So back to, I think, probably the slide that we were talking about, how many,
With the number.
right, with the numbers of people and then the extra 10%. What is the average caseload per attorney, given, that gap? in
Our caseload,
personnel?
post-COVID, our caseload has gone down, and so our number is not as grotesque as it used to be. But right now, it's about 360. That every lawyer will have 360 new cases. So that's per attorney per year.
Per attorney per
That's not open cases. Those are new cases that come in,
Okay.
and that's misdemeanors, juvenile cases, felonies. That's everything's in the mix in that number.
And in comparison, what would a Commonwealth attorney? No
You-
idea.
You'd have to ask
Okay.
them.
Just curious about the ballpark.
Because with the DPA while the talking point is often prosecutors handle all the cases and DPA doesn't, they're more specialized because the Commonwealth attorney handles just circuit court unless they do some prelims in district court. County attorney's doing just district court. Maybe they got some child support cases. So caseloads for prosecutors, I leave it to them as to how to calculate, but it'd be more complicated. For us, we do everything, so we just total everything up and divide by the number of lawyers.
Got it. Thank you. Thank you, Madam Chair.
Thank you. And when it comes to the recognition of flexibility that you've mentioned with the budgetary, and I was looking at the 6 requests, how would you manage that budget differently?
As far as
Assuming you have the same budget, but you want more flexibility. How would you manage the budget differently?
Yeah, so we had a bill that was proposed 2 years ago, and we're in the drafting stage of proposing it next year, which would simply give me the authority to set the salaries of attorneys within DPA, regardless of the ranges or the requirements of the personnel cabinet. So it would exempt, it wouldn't make them non-merit employees, but it would give me the ability to give unilateral raises without having to get personnel's permission. It would give me the ability to set different starting salaries at different places without pay equity concerns based on the competitiveness of the market. That's the kind of thing, those are the kinds of things I would do with some flexibility, but that's what I'm talking about. I'm still limited by the money I have. So I'd love to pay all of our lawyers $106,000. I just don't have the money for that.
And I think this is an appropriate question, so forgive me if it's not. But is there a legislator that you're working closely with on your draft legislation to propose this sort of flexibility?
Yeah, as of now, we're working with your co-chair, Representative Dietz.
Okay. That would be important, and we certainly would like the opportunity to review that during this legislative interim. I wouldn't want to be surprised with that in January, but I certainly am also on appropriations and revenue. So we would like to see that and project that. But the other thing that I find so interesting, and I'm grateful that Rob Sanders is coming up next, so we got a lot of questions for you, Rob, so be ready. But knowing that there are needs for paralegals, and you've got only so many tax dollars that can be recognized for this need, and we believe ultimately we're improving the safety in Kentucky. We're doing better as a state. We're not, but that's the objective, is to be doing better as a state. So my rose-colored glasses, we're projecting improved behavior by Kentuckians, less cases to prosecute, less cases to defend.
Right.
People are working. We have more people working. We're all healthier mentally. We're getting well. Is there a need for perhaps more paralegals and less attorneys, or the same amount of attorneys and some paralegals? I'm just thinking in total of budget dollars.
Yes. So there's not a need for less attorneys. I'll just say that first. We need more attorneys than what we have. Our request for paralegals is based on 2 things. Number one, turnover in public defender office. If we are able to address the compensation, it will reduce it. But this is a stressful job that's not made for everybody, and the burnout level's high. So there's always going to be turnover. By having consistent paralegals, that would provide some consistency in the service to clients and to courts, so that when that turnover occurs, we have a consistent presence helping on the case. So that's one of the factors. The second is in this age of digital discovery, when there's hours and hours of body cam footage and surveillance footage and interviews, all of this digital evidence, it takes a particular level of skill, or not a level of skill, a particular specialty of skill that I think paralegals could develop in some ways better than lawyers to deal with the current discovery. We no longer have files where they're buried this high of paper. It's all this digital information. And so having another member of the team that is able to develop a specialty, does not require a law license, that's cheaper on the state to pay, there's a real advantage to that. So I'm not willing to trade lawyers for paralegals, but as we're looking at how to improve the team, I think paralegals bring a lot to the table.
That is so great. Thank you. This was a very meaningful presentation. Thank you for that. And we'll look forward to having you on the agenda before the end of the interim. Oh, I'm sorry. Yes, please.
This is just a
Representative Decker.
comment, just an observation. I always appreciate your all's presentations. Thank you for the work you do. And I'm just thinking about your all of that you presented and how a budget and budget line items are really policy statements. And I think I've never heard you present before as balanced justice. I think that is a wise move on your part. I think that's really what you're asking for, is that, you know, the prosecutors are state funded as well. So we have 2 state funded people in the courtroom, and it's a policy statement. The disparate payments, I think we need to think of it as that type of policy statement by the state. So thank you for your presentation today.
I appreciate that. Thank you, Representative Decker. Thank you, Madam Chair.
All right. As our next presenters come forward, do you have a presentation that is queued? Okay, wonderful. Thank you. The overview of Life Learning Center programs and partnerships for justice-involved individuals. Thank you for being here today, and we're grateful that we'll have even some more questions. That was helpful contrast and comparison. So please introduce yourself and proceed.
You guys are really testing me today, letting me go after the DPA presentation, but then changing the topics of conversation. Sorry. Nevertheless, my name is Rob Sanders. I'm the Commonwealth's attorney for the 16th Judicial Circuit, which is Kenton County.
Good morning, Alicia Webb Edgington. I'm the president and CEO of Life Learning Center, Covington, Kentucky.
Thank you. And I also have to acknowledge, as we have such a commitment to a safer Kentucky, you're in my heart too, Alicia, with your past as a Kentucky State Police. And when one of ours is injured, I know that's heavy on your heart too. So I want to shout out to our police force.
Thank you.
Please proceed.
Start the slideshow for me.
Okay.
Well, good morning. We're here today to talk about the multidisciplinary recovery and reentry team, and really that starts back in 2015 with the implementation of the HEART program in Kenton County. And I want to give you a little bit of the background so you can understand how the HEART program has evolved into the MRRT and how we have now incorporated the Life Learning Center into being our partners in administration of the MRRT and still running the HEART program. HEART stands for Heroin Expedited Addiction Recovery and Treatment. This was a program that we implemented in Kenton County at the very early onset of the heroin crisis in Kentucky, which actually started with pain pills just before heroin, but quickly evolved to really an opioid epidemic. What the judges were seeing is that defendants who had opioid addictions were overdosing and dying before they could get the cases through the criminal justice system. So they began increasing those defendants' bonds to a point that they knew the defendant couldn't make in order to make sure that the defendant stayed incarcerated and stayed alive until we could get them through get them through the criminal justice system and into treatment. Just by ways of background, if you're not familiar with how things work in Kentucky when it comes to funding treatment, the state only pays for treatment after someone is convicted of a felony. So we would have to get them through the entire case, guilty plea, final sentencing, on to probation, and then the Department of Corrections would start paying for their treatment. Sometimes the Department of Corrections would actually say, we're not going to pay for the treatment until you've actually violated your probation, so it might even take longer. I began meeting with a good friend of mine named Burr Travis, who at the time was a criminal defense attorney in private practice. And Burr was different than all the other criminal defense attorneys I worked with because he got his clients into treatment on the front end of their cases, often before they were even bound over to the grand jury. He would come to us with a bed letter saying, I found a bed in this treatment program for my defendant, and if you'll agree to lower the bond, he'll go straight from the jail to the treatment facility. And Burr oftentimes would drive his client to the treatment facility himself. And we began talking about the difference between the outcomes for Burr's clients when he got them into treatment on the front end and all the other clients that were represented by every other defense attorney, whether private or public defender, that were sitting in jail for months on end. Even the best case scenario, it's going to take 3 to 6 months to get somebody in a felony case through the entire criminal justice system, sentenced and on to probation where they could get some treatment. And what we decided, what I convinced Burr of, was to come work for me because we wanted to implement this process that Burr was doing for his clients for everyone's clients. And I convinced Burr that if, right now you're only helping your clients, but if you come to work for me as a prosecutor and do the same thing only for all the defendants, you can get everyone's clients into treatment on the front end of the case. We can start letting them out of jail and into treatment, save tax dollars in the process. Kenton County Fiscal Court made an initial investment of $10,000 in our program that paid for substance abuse evaluations of these defendants. They were tailored to each defendant's particular place in life. Did they have financial resources? Did they have insurance? Were they a veteran? Were they homeless? Because some agencies had grants to treat the homeless. What program was close to their house? Did they need a program on a bus line because they didn't have transportation? We factored everything into these, and Kenton County initially started funding this with that $10,000 allotment. I don't even think we spent $2,500 of the $10,000 before the treatment providers realized that this was an excellent source of referrals for them to get patients into their programs. And once it began being funded by the Affordable Care Act, they saw it, quite frankly, as a money-making process because they could increase the participation in their programs. They started providing those evaluations for free, and henceforth the HEART program was run at no taxpayer expense beyond what they were already paying just to employ all the people that were already involved in the system. Fast forward a little bit, we had bumps along the way. We realized things like people were being released from jail and being picked up at the jail by their drug dealers and not making it to treatment programs. We got local transportation involved and provided public transportation straight from the jail to the treatment program so that we didn't have to worry about anybody not getting to the treatment program. Some people would walk in the front door and out the back door and obviously non-compliant at that point, but nobody was not delivered to the treatment program. Fast forward again, Burr worked for me several years before retiring again from the practice of law altogether. And although he remains close and involved, he's not working with this anymore. About the same time Burr retired from the prosecutor's office, the Life Learning Center came on board as a participant as well, and they founded and began running the MRRT. And prior to MRRT, our administration of the program included Burr in a spiral-bound notebook with every participant's name, and he would literally call every one of our treatment providers, which started out as 3 and multiplied over the years, and we've gone up and down a little bit as treatment providers have come and gone, but we maintain well more than 3 treatment provider partners now. But Burr would call each one every Friday and check off in his spiral-bound notebook, making sure that each participant was still attending treatment, they were still compliant with their probation, compliant with their treatment, looking for employment, things of that nature. About the time Burr retired, we brought the Life Learning Center on board, and they began running our multidisciplinary recovery and reentry team, which still meets every Friday, just like Burr did with each treatment provider, only now we do it in a centralized meeting, either in person or on Zoom calls, where we can have all the treatment providers in one place. Here we go. It's equal opportunity, Damon. They're setting it off for both of us. All the treatment providers in one place so that we don't lose participants in between one treatment provider to the other. Sometimes in the past, we had found out that somebody would leave one program and go to another, and they would be reported as non-compliant because they left program A. And what we didn't realize is that they weren't absconded from this program. They were enrolled in Program B because some reason it was close to their house, it was easier for their work, something along those lines. Anyhow, now it is run. We have one detective in my office who is employed and funded as part of our Rocket Docket program, which I will speak to in just a few minutes, and how the program has continued to evolve with the use of that detective. But now that detective is my representative on MRRT, and I will turn it over to Alicia to explain what MRRT now is and does.
So, thank you first for the opportunity to be here. Thank you first for the opportunity to be here today and to permit us, Madam Chair, to continue to expand on what we've been doing. The Multidisciplinary Recovery Reentry Team was just born out of the program that Rob indicated. We've just added a bit more of, I would say, sophisticated record keeping, if you will. What we did is we utilized a process that we adopted in the early 90s to do child abuse investigations. Multidisciplinary teams were brought together for us to review those cases because they are very complex, and oftentimes it involves children that their voice isn't always heard because of their lack of maturity and not understanding what has occurred to them. So we just took that process and we said, let's utilize that same process with the prosecutor's office. And Rob and I have been working. He prosecuted many of those cases that I investigated back in the day. We took that process and we refined it, and this is what we created under the direction of the Commonwealth's Attorney's Office. And if you will notice that as someone routes through this ecosystem, that MRRT continues to be the arm of accountability for this process to keep both the public defenders as well as the prosecutors engaged so that they know where the individual that has been charged or the individual for which they are representing is in the process. And as you will notice, as individuals traverse this particular ecosystem, they will be engaged at Life Learning Center. If I could just for a moment to let you know what we do at Life Learning Center. We are not a treatment facility. We engage with 7 treatment providers that have been approved by the Commonwealth's Attorney's Office. But we are a program that couples an education continuum with a care continuum to create a cognitive, transformational approach to changing how an individual is going to live their life outside of incarceration and sober. And in doing so, if an individual completes the programming, then the Commonwealth's Attorney in Boone, Kenton, and now soon to be Campbell counties will engage in a situation that allows them a great opportunity wherein, Madam Chair, you asked a moment ago about expungements. I want to tout what our Commonwealth's Attorney in Kenton County has done relative to MRRT and the numbers in 24 and 25. If you'll take a look at this, the numbers that were ordered to MRRT out of Kenton County, total Boone, Kenton, Campbell, 595. Kenton County, of course, has had the largest number at 506. If you'll notice, the total drug and or alcohol related, 81.8%. In Kenton County, it's 81.4%. If you'll notice that the total reported for noncompliance overall in Boone, Kenton, Campbell County, I guess it says something I can keep talking over noises. Yeah.
The missing child was located, so
Okay.
it's good news.
It is good news.
Yes.
And might I just say Cub Run is in Edmonson County. So
Is it?
yeah, it's my home. Yeah.
I didn't
part
know
of my
what Cup
hometown.
Run. Yes.
Yes. Okay.
Thanks be to God.
Yes. So, yes, thank you. So total reported for noncompliance in all 3 counties was 193. Kenton County reported for noncompliance is 171. Now, when individuals are not compliant, that is not an automatic pickup order. It the courts allow Life Learning Center to take these individuals, sit them down, have another conversation, and try to reroute them through that previous system that I just showed you, as I've indicated. They allow us to then look at, if you'll notice these 3 boxes: substance use disorder, inability to work or not willing to work, mental or physical health. We are able to route those individuals back into one of those categories. Inability to work and not willing to work, we have to reach out to the Commonwealth's attorneys, because many times individuals will provoke a conversation relative to substance use disorder and Social Security disability. And I do want to bring that to this policy group's attention. As we continue to work towards that, and I had an opportunity to speak to Representative Kulkarni when you all were in Northern Kentucky. Relegating a subset of people to substance use disorder, Social Security disability, we've never seen more than $1,000 of payment monthly for that. We really are relegating a group of people to poverty for the rest of their lives if we don't promote the opportunity for them to recognize the amount of work that they can continue to do and draw their disability. So I just wanted you all to know that if they are drawing disability, we do the math and show them how many hours that they can work so that they are not relegated to poverty. With that,
if
yes,
I
ma'am.
were to try to recognize that as an issue,
Yes, ma'am.
and we definitely want to put a pin in that, and Representative Kulkarni, if that's something that you're interested in continuing to work on, how did that person achieve the disability diagnosis? Because as a certified financial planner, I think by achieving that disability, they may have relegated themselves to poverty unknowingly, unwittingly. And what do we see moving back off of disability once they are feeling self-sufficient? Using the example that I think our advocates shared, that's a great example, but you don't want a person to have both. They need to get off of disability, because then they'll earn 10 times more.
That's a fair statement, and I am not a clinician, and I wouldn't begin to explain how the diagnosis was made for an individual that has, and the level and the depth of a co-diagnosis, co-occurring mental health disorder and substance use disorder. But what I would say, that it is the responsibility of all of us, having been a public servant nearly my entire career, to educate individuals so that they better understand that while they do have or may have a co-occurring illness that would perhaps, Madam Chair, disability, a portion of disability if that's so necessary, but also to educate them on the mathematical formula of how many hours that they could work, what they could pursue. And then oftentimes it does drive individuals, exactly what you said, to then saying, I do want to work full time, migrate them from disability into full-time work. And we've had a number of those cases at Life Learning Center. So I would not want you all as policymakers to think that I think that there's no room for disability. There absolutely is. There's situations where we recognize that individuals that are coming to Life Learning Center are out of our scope, that suffer severe mental health disorders, that have either been brought on by substance use disorder, or substance use disorder was then the linchpin to some of their chemical issues relative to their brain illness. And again, I'm open to having further discussion on that. But I want to let everyone know, obviously, I'm not a clinician, as many of you I already know, and you all know that. I want to tout, though, that, and I say this because I've known the Commonwealth's attorney for the better part of 3 decades. Our Commonwealth's attorney has been an individual that, for a former law enforcement officer would tell you he has been an advocate for law enforcement and supported us along the way as I traversed my career with the state police. But what I want to say is his pursuit of deferred prosecution is unmatched across the Commonwealth of Kentucky. And I say that because what he is doing to support individuals that are moving folks away from felony convictions is astounding. And with that, I'm going to let Rob speak to you about his program.
So our deferred prosecution program is run utilizing a single Commonwealth's detective, and what I did was hire a former probation and parole officer, or stole basically a probation and parole officer from the Department of Corrections. He's got experience dealing with people that are involved in the justice system. He's got experience dealing with people that maybe need redirection, that sometimes aren't cooperative, or maybe even perhaps lie to the people that are supervising them, things like that. It was just an excellent fit for what we're trying to do. And the point of the deferred prosecution program is to take low-level nonviolent offenders, put them into treatment, and for most of the purposes of supervision, rely on the treatment provider for the supervision to make sure that they are staying in treatment, staying clean, drug testing, and as long as they're compliant and enrolled and participating in the drug treatment, that's about 90% of what they have to do. My detective then has access to law enforcement databases to be alerted anytime one of those people reoffends. If they are rearrested and incarcerated, even if it's just brought in for driving without a license or DUI or any even low-level offense, if they're booked into a jail in Kentucky, he gets an email update and we can review what happened with that person for the purposes of accountability. The biggest thing about both the MRRT program and the deferred prosecution, which is part of the MRRT program, is accountability. We're not just turning these folks loose into the community to go commit new offenses or walk in the front door and out the back door of drug treatment, never to be heard from again, or at least not to be heard from until they get rearrested. And there are, I know, programs that occasionally people, nobody even knew they were missing. And here they are getting rearrested and sometimes making victims of crime where they shouldn't be, but nobody had done anything to bring the people back in the program. If someone is rearrested, we review their deferred prosecution agreement, see if it's something we want to revoke or and proceed with felony prosecution, or if it's a minor offense, we can impose some kind of sanction such as community service and continue them in deferred prosecution. But what we're doing with deferred prosecution is entering into these agreements after the cases are bound over to the grand jury, but before they are indicted. So anybody that agrees to this and complies with their agreement avoids felony indictment entirely. Everyone that can stay out of trouble, not get rearrested, and continue with their treatment for a year avoids felony prosecution on those charges entirely. Now, we don't do this with everyone. For instance, if somebody is already on felony probation, or maybe they just completed a felony sentence, they're still a convicted felon, deferred prosecution really doesn't help them because they're already a convicted felon. So those aren't people that we look for. The vast majority of the people that we enroll in the program are drug offenders. However, we have used the program and are continuing to use the program for other low-level nonviolent offenders that we are looking to give them the opportunity to avoid becoming a convicted felon. Every person.
Attorney Sanders, you have so much success. I'm going to ask you to go to your success slide.
Okay.
And because I've hogged this room too long, I've been told, and got to get out for the 10:30 meeting. But if you can wrap it up, please share the success because we need to see this. This is so meaningful.
Well, here's our 2024 numbers up on your screen. Every one of the people that stayed compliant with the program is one less person that the Department of Corrections has to supervise, which gives them more time and resources to devote to the people that they are supervising, which I think is very important because Department of Corrections, probation, and parole is overtaxed, underfunded, overworked, and the more people we keep off their caseload, the more meaningful the supervision they can provide to the people that are on their caseload. So that we started out, and this program started October 15th of 2024. So when we say 2024 numbers, that's only 2.5 months of this program. And here's what we're doing in 25 so far. You see we've already met the number of cases that we used in the 2.5 months. We have some people, the pending ones are ones we're trying to get back, the defense attorneys to get back to us. Compliments to the public defender's office. They're the easiest ones to work with. They know what our program is, and they're very prompt about getting with their clients, getting the agreement signed, getting them through the program. The private bar has been a little bit more, I don't think they're hesitant. They're not as in tune. They don't stay as informed like the public defenders have of what this program is and what's available. But there's our 2025 numbers, and we only think that these numbers are going to climb exponentially because right now a lot of the crowd, our potential clients, our potential people to use in the program, a lot of them have already been convicted of felonies in the past, so they're usually not being enrolled in this program now. As this program continues to age, we will have more and more people that get in trouble with the law that do not have a criminal record already that will be eligible for this program. So as we continue to have people hit their 18th birthday and become eligible for adult court, we will have more people that are eligible to enter in the program that can be that can benefit from the program. This program is funded through the Rocket Docket, which is separate and apart from MRRT, and it's a statewide funding mechanism. There is no funding source for this program other than that one detective position that's funded by the Rocket Docket. Outside of his funding, there's no other tax dollars.
And thank you as well. Your instructiveness is so important, and thank you for getting Campbell County involved on behalf of my Senate district. I'm very, very grateful for your work. And as you wrap up, Alicia,
Yes.
I know that Senator Webb has a question, but you finish with your slide, and then
Absolutely.
Senator Webb, please.
I will be quick. I just wanted to put, in context, the number of folks that we are still getting. Not all are deferred prosecution, but obviously most all of these folks, 79% have a criminal background, 70% struggle with mental health disorder, 76% history of substance use disorder. At Life Learning Center this year, we've already put 254 candidates through the program. 146 have graduated, so we still got many cohorts still going. We are on trajectory to graduate just shy of 400 this year. And as of year to date, June 30th, we've put $4.5 million back into the workforce of individuals going to work from Life Learning Center and into the Northern Kentucky region. And because of your recognizing of our program at Life Learning Center, we are expanding 25, 26, and 27. Our first new location will be in Moorhead, Kentucky, in conjunction with UK, St. Clair, and the Sisters of Notre Dame that brought us to Moorhead. So we're very excited. We already have a facility. We'll be at the corner of 2nd and Hargis Street there in Moorhead. And then we'll have 2 additional sites in 26 and 27.
Thank you. And Mrs. Secretary, would you please call the roll so that we can properly document this meeting? And I also would like someone to approve the minutes. Do I have a motion to approve the minutes from our last meeting? A motion from Cole Carney? 1, 2, 3, 4, 5. Oh, for this?
Not counting liaison.
Okay. Okay. Forgive me, we do not have quorum. Senator Webb, you have the last word.
Well, I appreciate it. Just briefly, I noticed stakeholders didn't include the private bar, and as much as I love my public defenders, I didn't see the criminal defense bar as a stakeholder, and I was wondering why that is, and wondering the role of the private attorney is they go through the system. Because like drug court, I'm not always thrilled, as much as I love drug court, not thrilled with the lack of my role as their attorney through the process.
When we say stakeholders, those are the people that participate in all of our MRRT meetings, and people that have bought into the system. We just don't have, with all due respect to the Northern Kentucky Bar Association, we don't have any mechanism for including the private bar in our meetings. It's not to say that private defense attorneys don't participate in the program or have clients participate in the program. They do. A handful of them that do this on a regular basis, and some more in tune with substance use disorders than others, are just better at it, and they put their clients right into it every time.
And I like to think I'm one of those, but I think if you're creating a program, maintaining a program, the private bar brings different perspectives. So I would ask to look at that. And in defense of the private bar, and I'm sitting here thinking rocket docket. Sometimes as a private practitioner, before I get a lab test, before I get a witness statement, a video, I feel like I'm malpracticing if I give my client up to a potential sentence without having that information. So I think that's the hesitancy of the private bar, and that's my conflict in some of this with the rocket docket, which I'm not real crazy about, because again, I feel like I need to explore everything. But that's just my thoughts on that.
Senator, just so you know, in Kenton County, we still provide discovery in every case. I know it's not the same in every jurisdiction, but in Kenton County, even if you put your client into the rocket docket, we still provide the discovery in the case. So you can always opt out of it midstream if you want to. Some of our judges will take a guilty plea with a lab report, without a lab report. Some of them will not. But we do provide lab reports as part of the discovery, and I've pledged to every defense attorney out there that I will sign an agreed 6002 order, which is setting aside a guilty verdict if the lab comes back negative and your client pled guilty because they thought they had drugs and probably just got fleeced by their drug dealer. Nevertheless, if we have a bad guilty plea, I'll sign the agreed order undoing the guilty plea.
And as we wrap up, August 20th is our next meeting, and we will be talking about specialty courts. I'll be convening that meeting, and I'll manage the clock a little better. But perhaps there's an opportunity for you to come back, because we'd like to get into perhaps rocket docket maybe just a smidge deeper. And the meeting is adjourned. Thank you so much for being here.